Nigel Farage has been in the news a lot recently to do with his banking. David Smith is a partner here at JMW Solicitors and heads up our data protection law team. So David, what exactly has happened between Nigel and his bank?
Well, I mean, I think some of the facts are still a little unclear, but I think there are two interesting data protection elements to it. The first is that Coutts obviously had an internal meeting essentially about Nigel Farage, during which they took minutes and recorded a decision. Essentially, it appears to get rid of him as a client one way or another, for whatever reason. Obviously, the precise reasoning is somewhat disputed, but he accessed those minutes by way of a subject access request, which is an absolute right under the General Data Protection Regulations. So one of the first things that comes to mind here is that organizations need to think carefully. If you're going to commit information about people to writing, and of course that doesn't mean you should just not write anything down, because that would be wrong as well, but if you are going to commit this kind of information to writing, you need to bear in mind that people can look at it. And if you write down something embarrassing, and that equally applies to sending emails about people between staff members saying what an annoying person or how irritating somebody is, or some other thing, you've got to bear in mind that this stuff can come back to haunt you. It's obviously lawyers are quite used to this situation, because there've been plenty of cases where lawyers have written or said unwise things in correspondence that's then come back to haunt them in court. But this now, the GDPR effectively applies that point to everybody. I mean, every organization needs to be aware that if you write something down about somebody, they can, in principle, access it, and you may maybe find yourself somewhat embarrassed on the news potentially about what you said.
And the data protection regulator, the ICO, has powers in relation to subject access requests and of course data protection generally as well. And I believe that they're conducting an investigation. Yeah.
So the other point, of course, is the position that an employee of the NatWest banking group, who's now, of course, resigned, so obviously sat down next to a journalist at a dinner and said, and basically, depending, again, unclear exactly what was said, but she certainly admitted to saying that he was a client. Well, she can't do that. That's again a breach of data protection rights. Now, what makes it particularly interesting, of course, is did she in fact breach the data protection law? Because by that stage, I think Farage had already recorded a video in which he actually said he was a Coutts client and that they debanked him. So in fact, arguably, she didn't break any law at all, because she merely confirmed something that had already been put in the public domain by Nigel Farage. So what's quite interesting about it is one, and the ICO, of course, have reminded banks that they hold a lot of private information about people, and that those rights apply no less to Nigel Farage than they do to anyone else. So banks should be careful about what personal information they're giving out, even about people who are famous, I guess, and what they're saying. But at the same time, where it's interesting from a legal perspective is that actually there's nothing unlawful about revealing information that's already in the public domain. So if it was merely a situation where all that was said was, yeah, this guy's a customer, and what he has said already is true, then it's neither here nor there. If there was more information given, so what's unclear is that the NatWest lady suggested that she'd merely said there were published policies about why someone would have their account terminated. As against that, Nigel Farage is suggesting that she said rather more than that. So if she merely said we have a policy and it applies to everyone, it's available online, then there's nothing wrong with that. If, however, she then went and said, well, in relation to Nigel Farage, we did da-da-da-da-da, and we debanked him for these reasons, well, they shouldn't have said that, because that was personal information. And that certainly wasn't in the public domain at that point, because Nigel Farage hadn't accessed the subject access request information and published it. So it's unclear exactly what's happened. But again, the point is that people need to bear in mind that they often have quite sensitive information potentially about people, and that stuff is covered by data protection.
And I'm sure we'll see what happens between Nigel Farage and the bank over the coming weeks. Just more generally, David, because I know lots of business owners worry about what they can and can't do, what the parameters are. How can you and the data protection team help ordinary businesses? Doesn't have to be somebody high profile like this.
No, we can help businesses and with policies. I mean, it's all a good starting point is to have a solid data protection policy. We can help people construct good quality policies, and also advise them on specific instances or incidents as they arise.
David, thank you for your insight. And if you'd like to contact David and the data protection team here at JMW Solicitors, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel for the latest legal news, hints and tips. I'm Dominic Walker, JMW's Inside Man.